Reserve time for rebuttal.
Reserve 3 minutes, Your Honor.
Thank you. We have both counsel before us, so we are ready to begin. Mr. Beatty, you may proceed.
Thank you. May it please the court, Scott Beatty on behalf of the appellant Jordan Chaikin. This case involves the question of whether this court's prior decision in 2021 that reversed the denial of a motion for summary judgment and included language that said and remanded for further proceedings on the Florida LLP's motion for summary judgment limited what the trial court was able to do on remand and precluded Chaikin from seeking to amend the counterclaim that he had asserted. There are two primary reasons that the summary judgment that was ultimately entered by the trial court was wrong. Number one was that the opinion in this prior decision, which throughout my argument I'll reference as Chaikin 3, did not foreclose or preclude the opportunity to amend. And second, summary judgment was not proper where Mr. Chaikin had filed prior to the hearing on summary judgment a motion to amend. We start first with the interpretation of the language contained in Chaikin 3, specifically the language that says we remand for further proceedings on the Florida LLP's motion for summary judgment. The obvious statement is if this court in Chaikin 3 wanted to limit the trial court to entering summary judgment in favor of the Florida LLP, the instructions could have been, or perhaps should have been, to reverse and remand for entry of summary judgment in favor of the Florida LLP. But the court did not do that. And because of the unique procedural posture that this case was in, there can't be a reasonable argument that that language somehow precluded Mr. Chaikin from asserting a motion to amend his counterclaim. This was an interlocutory appeal. What's really unusual about this particular case is that what was being appealed was the denial of a motion for summary judgment, which we all know is not an appealable non-final order. The trial court, however, in denying the motion for summary judgment, included a statement that said that the New York LLP had submitted itself to the personal jurisdiction of the court as an agent of the Florida LLP. And because the judge in denying the motion for summary judgment included findings with respect to personal jurisdiction, it became an appealable order, which was then appealed. This court is well aware of the cases that say that when a case is remanded after or on a decision that is made at an interlocutory stage of the proceedings, that the trial court proceedings on remand have to include the ability to amend. We cited in our brief, and I'm just going to reference two primary cases. The first is the Fitchner case out of the first DCA. This was a case where the first reversed and remanded with instructions to grant a motion to dismiss. But those remand instructions did not say whether or not the dismissal should be with prejudice or to enter judgment for the defendant.
But wasn't that case about, I mean, they forgot to include that language in there, so they went back to that.
No, that was the that wasn't the Fitchner case, Judge.
That's the other case. Okay. So, I mean, both of those cases, I mean, when we're looking at the distinguishing factors here, when this got remanded, the pleadings had closed and you had the argument, trial judge found for the defendant, that they could add the New York LLP. So when our colleagues sent the mandate, and said, on the summary judgment, that was where they were in the proceedings. But if I understand your argument, then you think it's a complete do-over. You start the time frame over, pleadings can come over, and the clock starts over in essence.
Yes, and the reason for that is Mr. Chaikin prevailed in the trial court. So when the summary judgment was originally filed in
He
2019,
prevailed based on the ruling that you could add the New York. No.
correct. So the opposition that was filed in 2019 to the motion for summary judgment said, if the court is inclined to grant the motion, we should be permitted leave of court to amend, which is every litigant facing a summary judgment puts that alternative argument. It never came to pass because Mr. Chaikin won. The court didn't grant summary judgment. So the fact that the appellate court reverses that decision can't possibly mean that simply because the trial court was reversed, that somehow the right of Mr. Chaikin now to amend disappears or goes away. That can't be the case. If this were, think about it this way, if this were a motion to dismiss for failure to state a cause of action or something, and it was granted 9.9 times out of 10, the trial court grants it with leave to amend. If an appellate court could review denials of a motion to dismiss, right, and say, no, we think that the motion to dismiss should be granted, that can't foreclose the possibility of that litigant to amend. And that's what happened here. The restrictive reading by the Florida LLP in this essentially denied Mr. Chaikin the right to amend his counterclaim ever. And and remember, this is a case that had been pending since 2016. There had been.
Let's talk for a minute about the proceedings in New York. Aren't Chaikin and the Parker Wakeman, including the New York entity, litigating in New York?
Yes, they are.
Don't those proceedings have priority at the time that the trial judge ruled on this summary judgment motion?
No, because the Florida proceedings were the first instituted proceedings. Those proceedings were
But
filed.
the New York LLP was never involved. It was challenging jurisdiction, or it wasn't here.
Understood, but remember, Judge, what they sued on was the agreement that they weren't even a party to. And
Then shouldn't it have been a motion to dismiss?
well,
You could have went a whole different direction with it, but we don't just allow people to, because you attach a contract, that automatically brings them into the litigation. That's what it seems you're asking us to do here. And then I think your comment that it foreclosed them forever, in this situation, perhaps it does because of the timing. But if that had been visited years before, when there's no statute of limitation, could you not have implemented your own action at that point against them?
But Judge, that's the point. This issue of the improper party, right? That the New York LLP is the proper party, was raised for the first time when they filed their answer, affirmative defenses, and motion for summary judgment in July of 2019, 3 years beyond when they sued and initiated the lawsuit. So Chaikin never.
How did that affect your ability at that point in time to bring them into the action?
Because they had sued on an agreement that was executed by the New York LLP. And up until the filing of their answer, affirmative defenses, and motion to dismiss, they had never argued or articulated a position that this is the wrong person. You're counterclaiming the wrong entity. And what they had to do was they had to say, we realize now that we never should have filed our lawsuit in the first place, so we want you to voluntarily dismiss the affirmative claims that we've made because those are improper as well. And during the summary judgment hearing, when this was argued, trial counsel for Mr. Chaikin at the time referenced, and this isn't really something that was brief because it goes to the Chaikin 3 decision, but there are cases that talk about when somebody gives the impression or when they file on behalf of an entity, and I'm looking at my notes to try to figure out the case. I believe it was the Rayner case about amending to correct the misnomer of a party when the other side sort of leads somebody to believe that the proper parties were in the lawsuit to begin with. So again, it's 2019 was the very, very first time that this was ever asserted. And again, because we're talking about an interlocutory order, he should have been given leave to amend. And at the time of the summary judgment, again, he had put in his opposition that he wanted to amend if the court was willing to grant it, but he won. And then after the decision came out in Chaikin 3, and prior to the hearing on the summary judgment, Mr. Chaikin formally filed a motion to amend his counterclaim. And what the Florida LLP argued successfully to the trial judge was, Judge Shenko, based on the language in this opinion, you have no discretion or authority to do anything other than grant summary judgment. And that is—
Didn't you also argue in Chaikin 3 that the possibility for amending should be there, and that while it wasn't specifically listed in the order, it had language basically that there was no merit to?
Well, sure, but
arguments.
But why? Let me explain why that doesn't really matter, and that's a red herring, Judge, because the decision in Chaikin 3 references the legally sufficient evidence that existed at the time. The appellate court in Chaikin 3 is confined and limited to the facts and record that they existed at the time. So the fact that somebody says, well, wait a second, we can amend, doesn't undo the fact that there was no record evidence at the time.
So you're saying that you shouldn't have made that argument to this court, in Chaikin 3, that it was improper for you to make that argument at the time?
I think it was probably a reach to argue that was an alternative basis. Because again, if you think about it, logically, it makes sense. If somebody—
since you did that, then couldn't you have also asked in a motion for rehearing or clarification on the mandate?
Well, I think with the benefit of 2020 hindsight, it would have been far cheaper for Mr. Chaikin to have done it at the time. But the failure to do that doesn't doom this proceeding. I mean, all the court said was for proceedings on the summary judgment. And at the time that the court in Chaikin 3 made that ruling, there had not been a motion to amend. So the court could have proceeded with proceedings on the summary judgment, and as is replete with examples of this, when there is a motion to amend, that the court can consider the motion to amend prior to ruling on summary judgment.
So I have one other question: that didn't they file the motion to amend actually before the mandate came out?
It was, yes, it was in between the time of the opinion and the mandate, but prior to the hearing on summary judgment. So again, because the basis of the Chaikin 3 decision again, the language that's used about the allegations about agency not being supported by legally sufficient evidence, or language from the scant facts on this record, and without further evidence of an agency relationship, whether they could, or again, the amendment concept was not something that was necessarily decided. And so for this court to, for it to be law of the case, it has to be an issue that was necessarily decided, and it's certainly not something that was necessarily decided, because again, it wouldn't make sense. Otherwise, everybody who appeals would say, well, look, we can amend. Therefore, that should be a basis to support a trial court's decision. With respect to the motion for leave to amend, again, it's very clear from the record and the transcript that the judge believed that he could not consider it. But in their briefing, the Florida LLP makes a couple odd arguments to say, well, even if it could, here's why amendment should not have been permitted. And the first is they say that Chaikin never filed a motion to amend after summary judgment had been granted. That, again, completely ignores the fact that they had already convinced the trial judge that amendment was not possible or permitted. And then they also talk about the rule 1.190 that talks about the ability to amend, and saying, well, he didn't have the right to amend. Well, this isn't an issue about 1.190 and amending a complaint or counterclaim without leave of court as a matter of right. It deals with the court's ability to grant a motion to amend. Finally,
you're right at 17. You got 5 seconds to 17.
Okay. Then I will stop now and use my 3 minutes on rebuttal.
Very well, counsel. Attorney Sandridge, the floor is yours, as they say.
Thank you. May it please the court, my name is Hala Sandridge, and I represent Parker Wakeman LLP, a Florida limited liability partnership, and Gerald Parker. Judge LaBritte, I'd like to quickly address the New York lawsuit question that you asked. That lawsuit was filed by the New York LLP in 2019, and at that time, the trial court did not have jurisdiction over the New York LLP. And that is what, in fact, was held by the Chaikin 3 panel. Through today, the trial court still does not have jurisdiction over the New York LLP. So under the principle of priority, the New York LLP's lawsuit in New York is the first filed lawsuit between these parties to the lawsuit. I would like to also address our tipsy coachman arguments that are particular to this appeal, because after receiving Mr. Chaikin's reply brief, I believe there's a dispositive issue that's arisen that has required affirmance. Specifically, Chaikin is here arguing that the trial court legally erred in denying his motion to amend to add a counterclaim. And in the trial court, we argue that that amendment was futile for various legal reasons. As you know, the trial court did not reach those legal arguments because it concluded that the remand language prevented the amendment. But on appeal, we argue that regardless of the correctness of that ruling, the court can affirm on the alternative basis that the amendments are legally futile. Given that we argued these defenses to the trial court, it should have not been a surprise that we were going to raise them in the appeal, and we did. They're at page 25 through 34 of our answer brief. And we argued that the statute of limitations and Rule 1.170 do not permit the amendment. So even if the court had concluded that the remanding language in Chaikin 3 didn't preclude the amendment, that it would be futile to allow those amendments.
Counsel, let me ask you a question on that, and I'm asking you to refresh my recollection. On the status of this record, the motion to amend filed by the appellant, was it accompanied by a proposed amendment?
It was,
Meaning an amended pleading.
yeah,
My
do not-
concern is on Tipsy Coachman. There's a requirement that we look at what's in the record that the same trial court had. If we don't have a complaint, then I'm not sure how we would apply the Tipsy Coachman rule. And the second part is, and I hate to say it this way, back in the old days when I was in private practice, there was a line of case law that seemed to suggest a proposed amended pleading should accompany a motion to amend, so that it would be before the trial court. And that's why I was asking about the state of the record for both the Tipsy Coachman and whether that old thought process was still law. But as to the latter, I can always look that up now later. But I just wanted to
Sure.
make sure what we had in the record on the Tipsy Coachman.
Sure. So what we do have in the record is their request to amend. I cannot recall right now, Your Honor, if it was accompanied by a motion.
I
But they did,
can check the record. Don't worry about that
Sure.
afterwards.
but they specifically stated what they wanted to amend to add. So let me give you an example. They wanted to amend to add a claim for breach of contract. And they said that it was based upon the actions in 2015. And all of this is cited with the record cites in my answer brief.
Okay.
And
Thank
it
you.
shows in the statute of limitations argument that it was all based upon 2015 and that they did not file their proposed request to amend, much less an actual amendment, until well after the statute of limitations had expired. But what's important, Your Honor, is not just that I raised this argument, that they didn't respond. And that's why I think something new is before this court. I think we have a concession because of a failure to respond to our statute of limitations argument and our Rule 1.170 argument that we're right. You don't get to just avoid those arguments by not responding to them in the reply brief and then say we win. They didn't. And so we believe that they are a concession and that we're entitled to an affirmance on those alternative basis. And I would, of course, object to counsel for appellant responding to those merits of those legal issues in his rebuttal. That would deprive my client of the ability to respond. On the other main point, I'd like to phrase this a little bit differently for oral argument. Assuming that the prior panel's remand instructions were in any way ambiguous, and we don't believe that they were, we believe that the issue this court must truly address today is who committed the error that caused us to be here today. And I almost heard an admission on that too today from opposing counsel that it would have been cheaper to ask the prior panel, well, are we going to have this right to amend? But they didn't. And we submit it was not the trial court, but it was Mr. Chaikin who made the decision to not seek clarification of the prior panel's opinion. And that's the error that was committed. Put yourself in the place of the trial court judge and consider what he had before him. He instead of conceding error in the prior appeal, Chaikin essentially abandoned the trial court's agency reasoning to find that the New York LLP was a party. And instead, Chaikin spent the majority of his briefing on alternative Tipsy Coachman arguments. So, when he says, well, we won on summary judgment, in the prior appeal, they abandoned it and instead argued 3 alternative arguments to support affirming. And one of them was, well, you can just allow this court, the trial court, to amend. And we hit that head on and said, no, you cannot allow the amendment. And we also argued that under the principle of priority, the amendment would be improper. So those issues were directly discussed in the briefing of the parties, put to the court as the major reason to either affirm or to reverse. And the court said, not only did it rule in our favor, but it said, and I think this is very important, that Chaikin raised several other arguments, in the plural, in defense of the circuit court's order, but they are unavailing. So the Chaikin 3 panel expressly rejected his alternative arguments, and it is law of the case. So this is unlike any of the other cases in which Mr. Chaikin relies on, such as Smith versus City of Fort Myers, where the court in the prior opinion does not say it, it's expressly rejecting any of the other tipsy coachman arguments. In reality, the entire appeal revolved around their tipsy coachman arguments, which included the trial court's ability to amend. And Mr. Parker and Parker Wakeman expressly asked the prior panel to not allow an amendment on remand, and the prior panel did just that. So when he received the opinion, Mr. Chaikin had a very strategic decision to make. And I've been through this before. Do you go back to the appellate court and seek clarification and maybe get an answer you do not like, or do you take your chances with the trial court? And they gambled, and they took the latter path, and they lost. They should have sought rehearing or clarification, and they did not. And we cited the R.J. Reynolds tobacco case versus Townsend to support our position that it was their obligation to ask the prior panel to clarify specific remand language. Remember, this was not general remand language. In fact, I thought the Townsend case was even worse than this, because the remand language apparently had an incorrect statement of law that said on remand that only the plaintiff had the right to request a new trial. And it turned out that that was wrong. But the first DCA said, look, you should have sought a request for clarification, and your failure to do so made that law the case. So, that kind of brings us full circle to the initial question that I posed. Let's put ourselves in the shoes of the trial court judge. He has specific instructions from the prior panel that says exactly what he's supposed to do on remand. The case law says that the remand language is specific. You can't deviate. The briefing confirms that the parties raised the amendment issue, and the prior panel found Chaikin's arguments expressly unavailing. Chaikin did not seek clarification. Under these facts and circumstances, I submit to this court that the trial court did not commit any error, that any error was caused by Chaikin in not seeking clarification from the prior panel. The trial court, having committed no error, we believe this should be affirmed. And if there are no further questions, I would rest on my briefs.
Thank you, counsel. Mr. Beatty, you have your 3 minutes remaining.
Thank you. Let me address first this issue about futility. I'm not sure why counsel believes that wasn't raised in the reply brief, because it is. The reason that the tipsy coachman arguments don't apply, which lead to a conclusion of futility, is that the proposed amended counterclaim, and Judge, I checked while counsel was giving her presentation, was attached. But the definition of a futile pleading is one that is insufficient as a matter of law, not whether or not there may be potential affirmative defenses to it. There's nothing in the counterclaim, the proposed counterclaim, that renders it insufficient as a matter of law. The Chaikin's position would be that the Florida Supreme Court case of Wells Fargo v. Sunshine says when a case is remanded, it's as if that erroneous decision had never been made, and that the Chaikin should have been permitted to assert a new theory of recovery, new claims, and the sufficiency of those claims could be tested by a motion to dismiss by the Florida LLP or whomever at that time, not prejudging it and precluding his ability to amend. I cannot overstate the fact that the issue about whether or not there was a proposed amendment would not remedy the record as it existed at the time to support the trial court's conclusion of an agency. Again, otherwise, everybody would always say, well, I can amend, and therefore that corrects an error because I can amend. The court was confined to the record as it existed at the time. And so whether Chaikin said, I can amend, doesn't change the fact that the record did not support the finding of agency that Judge Schenko relied upon in denying the motion for summary judgment. This is not a situation where it was expressly stated, Chaikin cannot amend. It was maybe intentional, maybe not, language that simply said to remand for proceedings on the summary judgment. There was nothing that prohibited Chaikin from seeking leave to amend prior to that proceeding on summary judgment. And the trial court erred when it refused to allow Chaikin the ability to amend, and this court should reverse.
Thank you, counsel. Thank you both. Well presented. We will